We live in an age where government regulations are not only intrusive, but sometimes are also totally unpredictable. Government regulations are one thing, but now we have court precedents that infringe upon government regulations, and it's very difficult for you to know and understand what you must do as a safety manager. For our purposes today in our discussions, we're going to be talking about accidents that have severe bodily harm or death involved with them. We're not talking about minor accidents now. We're talking about severe accidents. And we're going to talk about 5 things that have actually come into being since 2005. Many safety managers have never been informed of these. These are court precedents. They are not laws. This is the way the courts have been ruling recently. The 5 things that we're going to look at that might cause unwarranted damages or unexpected disasters for a safety manager are negligent hiring, negligent retention, driver negligence, functionally asleep, that's the big new one, and last clear chance. Basically, negligent hiring is up to you. You must do everything in your power to make sure that the person you're hiring is a safe driver before you put him on the road. I realize you don't have to give a road test to every driver that comes in. If they have a CDL and they have experience and the state they got their CDL from requires a road test before they get it, you don't have to repeat that. But you are responsible for making sure that they've never failed a drug test. I know one company cost them almost $1 million. They settled for $960,000 because their application didn't have a place on it where it says, "Have you ever failed a drug test?" The driver had an accident, and when it had an accident, it went into depositions. The opposing attorney said, "Have you ever failed a drug test?" And the driver said, "Yes, I have." Well, the problem was he had failed the drug test when he went for an employment interview. They sent him for a drug test, he failed it, so they didn't hire him. When the company then came along and did the previous employer checks, it didn't show up because he didn't work for the man. Negligent retention, that's also the purview of the safety manager. You must have all of your policies in writing. If you have a driver that continuously violates your policies, the courts have been deciding that because they don't obey your rules, you have no expectation that they would obey the rules of the road or the laws that the government has passed. Therefore, negligent retention has caused a lot of punitive damage judgments. And as you know, actual damage and punitive damages can be astronomically different. Punitive damages is what you're going to try to stay away from the most, because punitive damages, when a jury or a judge wants to punish a company for being illegal or not following the rules, they can amount to millions of dollars. There was a recent one for $60 million, a little over $60 million against one company, and another company was a brokerage firm, didn't even have a truck. And a judgment for over $20 million was handed down against them, all of it based upon either negligent retention or driver negligence. Now, as a safety manager, these 3 you don't have a whole lot of control over other than education. These 2, they will hold you directly and personally responsible for them. Driver negligence is basically your driver is illegal. He's out of hours, he's driving when he shouldn't be, there's bald tires on his truck, the brakes are defective, something that should be fixed and that the driver should catch on his PTI. Functionally asleep. You have a bad accident, somebody's killed, the first thing they're going to do is subpoena the cell phone records of the driver. And if that driver, when he was supposed to be resting in the 10 hours that he's registered in the sleeper berth, if he's making and receiving phone calls that whole time, when he starts driving again, he's functionally asleep. He's not rested. And if they can prove in court that your driver was not rested, that you didn't train him properly on getting the proper amount of sleep, then you can go into punitive damages. Last clear chance. That's basically what it says. If they can prove in court that your driver, as a professional Class A CDL holder, had the last clear chance to prevent an accident and did not, you can be liable for punitive damages. I'll give you an example of that. If a vehicle is parked on the side of the interstate with part of the vehicle overlapping from the breakdown lane into the travel lane, and your driver hits that vehicle, even though part of it's in the travel lane, he can be liable, or your company can be liable under the last clear chance rule. Today we're going to talk only about negligent retention. Negligent retention brings to mind something that's very important. The HR companies have used it for a long time. It's real simple. If it's not in writing, if it's not signed, if it is not dated, It did not happen. Remember that, because if you go to court under negligent retention, the first thing they're going to do is ask you to prove it. Under negligent retention, you must give your drivers a copy of all of your company policies. Everything they're held responsible for must be in writing. They must sign for it, and you must keep a receipt for those things in their driver's file or in their HR file. If you don't have that and you go to court, you can be found liable for punitive damages simply because you cannot prove you ever trained your driver. If your driver has a history of citations, traffic citations, and you cannot prove that you have trained that driver or retrained that driver, then you can be liable for punitive damages. A case went to court just recently where, under depositions, they asked the driver that was involved in the case if he had been trained on how to recognize accidents before they happen, if he'd been trained and he knew how to keep his eyes moving, get the big picture, and look far ahead, and he said no. And it looked like the company was going to have to pay punitive damages. The opposing attorney had wanted $3 million in this particular accident, and when the company's attorney could produce written documents signed by the driver, dated, and prove that he had been trained in these things, the demand went from $3 million down to $1 million, and they were able to settle it out of court. But in that case, just a written document saved them $2 million. Under negligent retention also, if your driver has had an accident and you don't have a written policy covering retraining and discipline for a driver that has an accident that is considered his fault, then you can be eligible for punitive damages again. You must not only retrain the driver, but you must prove that you retrained the driver and, if necessary, show the court what you did when you retrained the driver. These things have never been necessary before, and now they're necessary in just about every case that goes to court. Another part of negligent retention is if you treat one driver different from another driver. If you have two drivers, both of them receive a citation for an improper lane change, and one of them you like really well, so you give him remedial training. The other one, he's giving you trouble, he's got a bad attitude, so you fire him. You have just opened yourself up to punitive damages, because the man that you kept on, if that man then has an accident and you didn't fire him like you were supposed to, you can be open for punitive damages. He has proved that he's an unsafe driver because he made an unsafe lane change, and if that case goes to court and you have not retrained the driver and proved that you've retrained the driver, you can be open for punitive damages. This negligent retention involves a lot more than that. And if you want to, we'd be more than happy to come and explain the rest of it to you. But the purposes of this DVD is just to show you there's so much you have to keep records of. You have to make sure that they're available and that they're provable. If you go to court and you can't prove what you need to prove, you're going to be in big trouble. You might even have a deal breaker for your company that would cause it to go bankrupt.